Hello again, and welcome to the New York Employment Law Show. I'm Scott Peterson from Durazzo Peterson LLP, and we're here today to talk about common questions and answers in New York employment law matters. The goal of this show is to provide you with information because if you're here, you're obviously looking online to try to get answers to some questions that are specific to you, but probably very common to someone who handles this day to day. So today we're going to talk about how employment lawyers get paid. If you think you have an employment law problem, one of the questions you're probably asking is, how can I afford to handle this? I may have just lost my job, my family may be in dire financial circumstances, or frankly, it may just be very expensive for me to pursue this. So how does this work? The answer is that different firms and different lawyers handle these kinds of cases very differently. Some firms will charge you by the hour to pursue your employment discrimination or your employment litigation claims as far as you'd like. The way that this works is they'll say, okay, well, turns out that you may have some kind of a legal claim here arising out of your termination. Your options are many, including filing a complaint with the EEOC or filing a lawsuit, and that is going to cost you $300 an hour, and we're going to need a $20,000 retainer in order to move forward. You may think to yourself, wow, that's really expensive. How can I possibly afford that? Other firms, the other way that lawyers get paid is by saying, okay, look, we've evaluated your case. We think that you have a strong case of, let's say, sexual harassment. We are willing to take your case on a contingency fee arrangement. What this means is that we will work on your case, we will put in the time necessary to take your case to a point where we think we can get you a successful resolution, and frankly that may be early on or that may be at trial, and we're willing to do that without charging you by the hour. In exchange for that, our fee is going to be a portion or a percentage of any recovery that we obtain for you. So the common percentage would be 1/3. So use a basic example. If we accepted your case on a contingency and we went through the process and we obtained a settlement of $90,000, our fee would be $30,000. Your portion would be $60,000. Now, the upside of that for someone in your position is the knowledge that you can pursue a claim and you have an attorney working for you, and you won't be getting monthly bills, and you won't be getting billed for every time you call the office or you send an email or you ask a question. The upside of it from the attorney's perspective is knowing that they're not taking money from someone who probably doesn't have a lot to spare. The problem with employment cases is that, like we said in the beginning, a lot of times people come in and they've lost their job and they have a family to support, and the prospect of spending a lot of money to pursue a claim, even if they were wrong, is really intimidating for them. So the contingency fee agreement helps to alleviate some of those concerns. The third option is a flat fee arrangement where you might pay a specific amount of money for a specific service. So for example, if the attorney says, we think you can file a complaint with the EEOC or the New York State Division of Human Rights, and we're willing to do that for you for a flat fee of a certain number of dollars, a couple of $1,000s or a few $1,000s depending on the circumstances. This is another way to control the costs and prevent you from having to be concerned about, well, am I going to be billed every single time I pick up the phone or I send an email? It's a good way to kind of alleviate some of those issues again. There's also the prospect of a mixed fee agreement where you might pay a little bit up front and then the fee might shift to contingency as the case goes on. That allows you to have some measure of comfort or security that the fee is going to be capped in terms of the expenses from your pocket. The other thing we want to talk about is consultation fees. Different firms handle this differently, and the reality is that employment cases are complicated, and for an attorney to properly evaluate your situation, it may take a while. It may require a lot of review of documents, it may require a meeting, it may require some legal research. So sometimes attorneys feel the need to charge a consultation fee because frankly, if they didn't, and they just gave free consultations to everyone, they may very well go out of business because they would have no revenue coming in. So it's really a balancing act. And our firm doesn't have a blanket policy. We generally handle cases on contingency or some version of a mixed contingency flat fee arrangement. We do this because it offers clients the opportunity to work through their case and pursue a wrong without having to undertake a large amount of risk personally. It's nice when they have some skin in the game, so to speak, and they have paid something, so they have a vested interest. But we don't ordinarily charge by the hour for entire cases because we don't think it's the best way for us to build a good attorney-client dynamic. So, if you have questions about employment law issues, we're the place to turn. Feel free to reach out to us, send us an email, give us a call, visit our website. We're happy to talk with you. Until next time, thanks.